Ms. Kinsler.
Thank you, Your Honor. First, I would like to talk about the enforcement. The violations that were filed, 11 of the violations had already been paid, yet Ms. Mitchum included those violations in an enforcement. 9 of the expenses that Ms. Mitchum had included in the enforcement had never been provided. Those invoices were never provided. So when you heard testimony from Ms. Mitchum and argument from Mr. Gilbreath that there were expenses paid after the fact, that was because those invoices were finally provided on February 26th after the enforcement was filed. Once those invoices were properly provided to Mr. Hendrix, pursuant to the final decree of divorce, he paid them within 14 days as he's required, as he always does. I am asking for a clarification regarding the summer camp issue, as it is very clear that summer camp is quite different than a one-day camp provided through a daycare. Additionally, I would like to point out that the request for Ms. Mitchum to throw Mr. Hendrix in jail for 6 months was for a total of $1,300 in violations, which just so happens to be about the same price as the car payment of Ms. Mitchum's car, which leads me to the modification issue. I'd like to go through the lens factors, as that's what the court looks at. So when we look at reasons for and against the move, the main reason for the move is Ms. Mitchum's allegations that Thomas's trust is going to run out of money. That is the crux of the entire argument. Yet, even as we sit here today, I can't get supporting documents showing that there is a $10 million trust and what exactly is being paid by the trust. Ms. Mitchum currently has almost all of her expenses being paid by the trust, yet both Mr. Jones and Ms. Mitchum refuse to be gainfully employed, refuse to change their spending habits in any way. They purchased $10,000 worth of cats this summer. That's not for an ag exemption. That was what they chose to do with their limited income of $2,000 to $3,000 a month. Ms. Mitchum has spent thousands of dollars on this divorce case, alleging that that money did not come from the trust. And I just do not see where, based on her representation that she's only making between $3,000 and $4,000 a month, how she'd be able to financially provide for that. Additionally, Mr. Jones and his daughter are living in the house, again, without financially contributing in any way possible. His business is benefiting and receiving money for upgrades to the house, yet none of that's been provided as well. So the reasons for the modification are argument by Ms. Mitchum without any supporting documents, in my opinion. So now we get into the more important parts, the reasons against the move. Mr. Hendrix, it's clear from the testimony, is honestly the one parent that is actively involved in Gemma's life when it comes to school, when it comes to showing up to extracurricular activities. And all of this is going to be pretty much taken away if Gemma moves to Lampasas. It is an hour-and-a-half commute one way, and that is taking away Mr. Hendrix's ability to sit here and participate in extracurricular activities, school involvement. Maybe on the bare minimum, his extended standard possession order might not be affected, but it's going to have a ripple effect as to everything outside the set possession time. It is also going to be, I think, difficult for Mr. Hendrix to, after he gets off of work, to be able to pick up Gemma when school gets out if he has to drive an hour-and-a-half away. The argument that Ms. Mitchum can move anywhere within Travis County, again, for the first time yesterday, it was confirmed that they're moving, which I think is a surprise to Mr. Hendrix, as he believed that this was just speculation, as he said, conjecture. I also want to get into the other lens factors. You did not hear from any educators from Lampasas ISD. You did not hear from any educators, period. The argument by both Mr. Jones and Ms. Mitchum were, well, the ratios are better. The facts that you heard from that are there's a 3-student difference. So there really is no difference. However, on a whole, if you look at everything beyond health and leisure opportunities, Gemma is currently in an area where she has friends surrounding her. She has involvement in a school community, a community pool. Her classmates from previous years are nearby. She has neighbors nearby. She will lose all of that by moving to a 200-acre farm in the middle of nowhere.
Ms. Kinsler, I just wanted to give you your 1-minute warning.
Thank you, Mr. Beck. Additionally, the effect on extended family. You heard for the first time today that Ms. Mitchum has rekindled relationships with extended family who just happens to be out in Lampasas. While Mr. Hendrix's family lives nearby in Cedar Park and would be directly affected by an hour-and-a-half move. Again, the main argument here is the effect on Mr. Hendrix's visitation with Gemma, specifically as to maintain a full and continuous relationship with Gemma, which has been a struggle anyway with Ms. Mitchum, and adding distance to this factor is only going to make it worse. Mr. Hendrix is asking that all the requested relief be denied. If Mr. Gilbreath is saying, well, the court has the ability to do anything they want regarding geographic restriction, then limit the geographic restriction to Lakeway, and we can avoid all of this speculation going forward. Mr. Hendrix is asking for attorney's fees, specifically as to the enforcement, which we believe was frivolously filed as harassment. We thank you, I thank the court and Ms. Williamson for being patient with me. Thank you.